Hi, my name is Steve Lasher. I'm chair of the Michigan Tax Tribunal. This presentation is presented by the State Tax Commission and is intended to provide information with respect to the 5 key things that assessors need to know in defending their assessment at the tribunal in a small claims case. The following are the 5 key things assessors need to know about defending your assessment at the tribunal. First, understand the process, participate in the process, know your responsibilities and be prepared, present credible evidence, and understand your appeal rights. First, in understanding the process, know that hearings are 30 minutes in length. This means that each party has approximately 10 to 15 minutes to present your case. Use this time wisely. Make sure that the hearing referee or tribunal judge understands your evidence, your contentions of value, and your critiques of petitioner's evidence. Cross-examination or the direct questioning of petitioner or petitioner's representative is not allowed. You cannot ask questions of petitioner, and petitioner cannot ask questions of you. All testimony and questions must be directed to the hearing referee or the tribunal judge. There's no formal transcript or recording of the hearing. Although parties may record a small claims hearing, that recording cannot be used for any purpose, including an appeal to the Court of Appeals. And finally, hearings are always held in the county in which the property is located or in a county adjacent to that county. By statute, petitioners will not be required to travel more than 100 miles to a hearing. Unfortunately, respondents are not provided that same statutory limitation. The next point is participate in the case. Always file an answer to the petition using a current tribunal form. Answers must be filed within 28 days of the issuance of the notice of docket. Always file your evidence at least 21 days prior to the date of the hearing. If evidence is filed after the 21-day limitation, your evidence may be excluded. Evidence will be excluded if the hearing referee or tribunal judge determines the petitioner would be prejudiced by admitting your evidence. All documents and requests must be timely filed with the tribunal, and a copy must be sent to petitioner. Upon receiving petitioner's evidence, review that evidence and determine if you can identify any information that contradicts petitioner's evidence. If so, you may file that evidence and send a copy to petitioner as rebuttal evidence at any time, or even on the day of the hearing. Rebuttal evidence is limited to that which relates solely to evidence submitted by petitioner. Attend the hearing. If respondent fails to attend a hearing, a default hearing will be conducted, and that means that all of respondent's evidence is excluded from consideration by the tribunal. If petitioner fails to appear for the hearing, the tribunal will dismiss the case unless respondent wants the hearing to continue. For example, if respondent believes that its evidence supports a true cash value higher than the value on the assessment roll, respondent can ask that the hearing go forward. Finally, hear on file and telephonic options are available to either party. However, respondents should be aware that a hearing held on the file limits the hearing referee or tribunal judge's ability to question respondent in order to better understand the evidence. The next point is be prepared and know your responsibility. The tribunal believes that an assessor has 2 jobs. First, assessors must follow State Tax Commission guidelines, policies, and procedures in preparing the assessment roll. However, when defending an assessment at the tribunal, assessors must follow the Michigan Constitution, statutes, and case law in presenting evidence of true cash value, taxable value, and assessed value. For example, the State Tax Commission mandates the use of a 2-year sales study to assess property. Because the study does not include sales after September 30th, it may not constitute the best evidence of the value of property as of December 31. You must be able to support your evidence. This includes support for land values, ECFs, etc. You must review petitioner's evidence and be able to critique it. You should provide rebuttal evidence where appropriate. And finally, where tax years after the year of appeal are included in the hearing, you must provide evidence of value for that subsequent year. The next factor to consider is provide credible evidence. Understand your evidence and be able to explain it to the hearing referee or tribunal judge. If relying on the mass appraisal cost approach, you must support your land values, ECFs, depreciation, obsolescence, and all other information on the record card and valuation statement. Do not submit property record cards for the wrong year, cards where their value is overridden, or cards that conclude with calculations too long. Support for land values and ECFs must include sales studies. If you're using the extraction method to determine land values or for ECF purposes, you must be able to explain the information relied upon and support your methodology. If relying on a sales comparison approach, you must identify comparable sales as close to the assessment date as possible, including sales after December 31st. You must also be able to show the hearing referee or tribunal judge that your adjustments are based on market information and can be supported. The next step is understand your appeal rights. If a hearing referee or administrative law judge issues a proposed opinion and judgment, or POJ, you may file exceptions to the POJ within 20 days of the date of its issuance. Exceptions are encouraged if you believe that the hearing referee or ALJ has ignored or misunderstood your evidence or has misstated or misinterpreted applicable law. The opposing party can file a response to filed exceptions within 14 days of your service of those exceptions. A final opinion and judgment, or FOJ, will then be issued by the tribunal. If a final opinion and judgment is issued by the tribunal, you may file a motion for reconsideration that must show that the tribunal made an error of fact or law. A motion for reconsideration must be filed within 21 days of the date of issuance of that final opinion. The opposing party may not file a response to the motion for reconsideration unless specifically ordered by the tribunal. Finally, you can appeal to the Court of Appeals. Either party may appeal a final opinion from the tribunal to the Court of Appeals. If the appeal is timely filed within 21 days of issuance of the final opinion, after any motions for reconsideration are considered by the tribunal, the Court of Appeals must hear the appeal. If an appeal is not timely filed, the Court of Appeals has the option of hearing the appeal. The State Tax Commission and the Michigan Tax Tribunal hope that assessors and local units will find this 5-minute series video presentation regarding the 5 key things you need to know about defending your assessment in a tax tribunal small claims hearing to be a beneficial tool in assisting you to better prepare for and present evidence in a small claims hearing at the tax tribunal. For your information, the tribunal has been presenting 6-hour renewal classes on this topic throughout the state. Further information on this topic and other tribunal issues can be found on our website at www.michigan.gov/taxtrib or in our monthly Gov delivery. Thank you.